SJC-12142, Mount Vernon Fire Insurance Company, v. Visionaid, Inc.
Still, good morning, Mr. Berman. You get points for patience, but then again, so does Mr. Duane, so evens out.
Thank you, Your Honor. May it please the Court, my name is Kenneth Berman. With me is Heather Rapicki. We represent Visionaid. There are two basic questions on this appeal. One is, when is a liability insurer required to pay for the prosecution of the policyholder's counterclaim? And the second question is, does a conflict of interest exist here, entitling the policyholder to select independent counsel to handle the defense? The conflict exists in this case because Gary Sullivan is suing Visionaid, the policyholder, for age discrimination. Visionaid has a $500,000 misappropriation counterclaim against Sullivan, and Sullivan is willing to drop his claim entirely if Visionaid releases its counterclaim. The counterclaim, therefore, stands as an obstacle to settlement.
We don't have to decide the question of whether or not there's a conflict, right? I mean, that's not the question that was certified by the First Circuit.
I agree with that, Justice
So
Lang.
we have to answer the questions that were certified to us, not the questions that perhaps both parties would like us to answer.
I agree. They said if the insurer has an interest in devaluing the counterclaim, does that create a conflict of interest entitling the insured, the policyholder, to select counsel? And that is exactly the question. So
the First Circuit will decide if there is the conflict.
I believe that they will decide if the policyholder has an interest in devaluing the counterclaim.
Right.
And then the question is, if they do, then is it this court's view that that entitles the policyholder to select independent counsel to handle the defense?
And that's a separate question from whether or not the insurance company should pay for all of the counsel.
It's a separate question from whether they have an obligation to pay for the prosecution of the counterclaim. That's correct.
Did you already say this? Is it definitely a compulsory counterclaim?
It is a compulsory counterclaim.
Everybody agrees with that.
Mount Vernon admitted it in its Rule 30b-6 deposition.
Let me ask you a question. You know, you say that there's this obligation under the contract and under the rule of basically in for one, in for all, for the insurance company to be obliged to prosecute the complaint, the counterclaim, and to pay for it. But the contract gives the insurer the right as well as the obligation to defend. And if you are right that this is part of the defense, would the insurer have the right to pursue a counterclaim that the insured did not wish to have pursued?
The counterclaim.
I mean, there may be instances where, you know, the insured does not want to pursue a counterclaim, maybe for business reasons or for any number of reasons. But the insurer decides it's part, if it's required to prosecute counterclaims when they're part of the defense, decides that as part of the defense, it's a good idea to bring these counterclaims, whether permissive or compulsory. And does it have the right to do that?
The right is determined by what's in the best interest of the client. It's the protection of the client that's of concern. If the client owns the counterclaim and the client believes that it is not in the client's best interest to pursue the counterclaim, but the insurance company does believe that it's in the best interest to pursue the counterclaim, then that creates a conflict of interest, which would entitle the policyholder to appoint the counsel to represent the policyholder's interest.
Take the insured's point of view?
To take the insured's point of view, that's correct.
So it is just when you look at the country in terms of the number of courts that have reached this issue, am I correct that the majority is on the side of Mount Vernon as opposed to you?
I haven't done a head count on that, Justice Botsford. There are a number of cases that side with Mount Vernon. There are a number of cases that side with us. But we believe that the cases that side with us are consistent with the insurance laws that's already been developed in Massachusetts in two cases in particular. One is the Hayes and Paper case and one is the GMAC case. So Hayes and Paper is interesting and on point because in Hayes and Paper, the issue was whether it was a question of insurance policy interpretation. There was a conflict outside of Massachusetts on how that issue was going to be resolved, and there was split of authority. And the issue was whether the word suit in an insurance policy and a clause that says that the insurer has an obligation to defend a suit imposed on the insurer an obligation to defend against a claim letter.
Was it EPA?
An EPA claim letter, exactly. And despite the holdings from other states, this court held that even though the claim letter was literally not a suit, the letter was so substantially equivalent to a lawsuit that a duty to defend arose immediately. And important to the decision was this court's observation that early involvement in the settlement discussions after receipt of a claim letter is often crucial to protect the policyholder's interest. And that same rationale applies here. because
But can I just play devil's advocate
Sure.
on that? I mean, the fact is, it's a letter, the EPA is sending a claim letter against the insured. So defending the insured might include the claim letter. Here, you are prosecuting on behalf of the, or you're not, you're asking Mount Vernon to prosecute on behalf of the insured. I mean, defend is a fairly important word in this
The significance of Hazen paper is how we resolve an issue of policy interpretation. And we do have the word in the policy that says defend, and we have defense costs, which are a defined term. And we have a difference of opinion as to whether defend includes prosecuting a counterclaim that is either compulsory, that's intertwined with the defense, or that would help to defeat liability or diminish damages. And we say that defend includes all of that. They say, no, defend doesn't include that. Defend only means providing representation for the portion of the lawsuit that's defined by the denials in the answer and the affirmative defenses, or to defend a lawsuit that has an answer that has no counterclaim.
Why isn't this just really simple? Why isn't a counterclaim not a claim against the insured that has to be defended? I mean, as I understand the situation, you have your insurer, and they are all over the language of the policy. It talks about the duty to defend and defend any insured, and this is a counterclaim.
This is a counterclaim, but the counterclaim is intertwined with the defense, and it's a
Not necessarily. It's because one's a discrimination, another one's a misappropriation of funds. You could have, as unlikely as it is, you go verdicts go in different ways.
Theoretically, that's possible, but even Mount Vernon admitted in its Rule 30b-6 deposition that that's unlikely to happen. The best defense that Visionaid has in this case is to prosecute the counterclaim. The counterclaim has already had a magnificent impact on the defense of the case.
Well, you can prosecute the counterclaim. It's just whether or not everybody has to pay insurance for you to be able to have your insurer do it, or whether you do it yourself.
Well, but that's when we get to the GMAC case, the in-for-one, in-for-rule case, in-for-all case. And the rule in GMAC was if an insurer is required to defend, and I'll get to the word defend in a minute, if the insurer is required to defend any claim in a suit, the insurer cannot parse the suit into covered claims and non-covered claims and provide counsel only for the covered claims.
But that's a different situation, isn't it? I mean, does that really cover this counterclaim situation? I understand what that means. I've seen that before. It's a multi-count lawsuit.
Right.
Not all of which has to do with what the insurer is clearly obligated to defend on, but that's not what this is.
We need to look at the reason for the in-for-one, in-for-all rule, as it was articulated in GMAC. And the reason is that it's not feasible or practical to divide a lawsuit into insured and non-insured claims and to have an insurance company provide representation for only the insured pieces of
But
the
in this
lawsuit.
case, it's pretty compartmentalized. I mean, would you say that they had to defend the counterclaim if it were not related to your underlying claim?
If it was permissive rather than
if
compulsory?
Right.
If it were, I believe that the standard is, if it's a compulsory counterclaim, if it's intertwined with the defense, or if it would help defeat liability or diminish damages. And the standard is, what would a defense lawyer do who's retained to represent this defendant in the case? What would a reasonable defense lawyer do? Because the standard of professional conduct is determined by Rule 1.3 of the Rules of Professional Conduct, which require the lawyer to provide zealous representation. So if in connection with that representation, it would be, the lawyer would deem it to be to the client's advantage in the defense of that case to assert the counterclaim, then yes. But I can see that a permissive counterclaim, which is unrelated to the lawsuit, let's say for only $5,000 when they're being sued for $1 million, is probably not within the insurer's duty to defend. But the reason for the in-for-one, in-for-all rule, there are two reasons for it. One is for sound judicial administration, and the other is for client protection, because clients are poorly served, as I submit so is the administration of justice, if representation in a suit is allocated based on the randomness of insurance coverage, because a party in a lawsuit is entitled to have cohesive, coordinated representation by a lawyer who's keeping his or her eye on the whole suit and on what serves the client's best interest and not just looking at a segment of
The
the
issue is
suit.
who's paying for that lawyer, isn't it?
I'm sorry?
Isn't the issue who's going to pay for that lawyer?
Well, yes, but
And what the other side brings up on policy grounds is you're setting up an inherent conflict of interest because people are going to have different opinions about the validity of the counterclaim.
no, I don't think there are any different opinions here about the validity of this counterclaim.
Right, but I just meant in general, if we adopt your rule.
Well, in this particular instance, the insurance company has already used the threat of the counterclaim to get Sullivan to reduce his demand down to zero, and has now said, well, now that we've used your counterclaim to bring the demand down to zero, you have to prosecute it yourself. So they're willing to threaten the counterclaim for defensive purposes, but they're not willing to prosecute it, and they want the insured to prosecute it.
Now, refresh my memory here with regard to employment law, putting aside the counterclaim. If there were a finding that there was age discrimination here and that it was later determined that he had stolen money from the company, does that have any impact on the scope of damages?
Yes, it does, Your Honor. That's under the McKinnon rule, because even if the termination was for discriminatory purposes, damages are cut off from and after the moment that the company discovers that it had legitimate grounds for the termination. That's the McKinnon rule. And so what the insured, in this instance, the insurance company says, well, all we need to do is just prove that the employer thought that the man stole money, not that he actually did steal money. And I submit that that would be a pretty anemic defense. And in fact, it would be to the insurer and to the policyholder's advantage to prove that there actually was misappropriation, because even if there was a discriminatory motive for the termination, it would cut off the right to damages from the time that the misappropriation was discovered.
So your view is that it would be ineffective for counsel not to bring some type of claim in order to limit the scope of damages if it were to lose?
That's correct. No reasonable defense attorney would avoid prosecuting this counterclaim. If they didn't, juries do not.
Could you pursue that without pursuing a counterclaim? Would that be part of your defense, or would there have to be a counterclaim in order to invoke the McKinnon rule?
It's possible that you could do that as a defense, but it doesn't make any sense at all from a strategic matter, because if you prove the counterclaim, it proves that Visionaid was the victim, and juries do not rule juries rule for victims. They don't rule for the people who do the victimization. And if we don't pursue the counterclaim, then what happens, if the counterclaim is not part of this case, then a jury could easily come to the conclusion that the reasons that were proffered were pretextual, because if they were legitimate reasons, why isn't the employer suing to get the money back?
Well, let me ask you this. It doesn't seem as if this was part of the bargain, the contract bargain. I mean, I'm willing to bet that the insurer never imagined in a million years that it would be required to prosecute, not defend, but prosecute this counterclaim. I understand all of your policy arguments about why this should be the way it is, but that's not the understanding that people have when they enter into these insurance contracts.
I disagree. The reason I disagree is this is an employment practices liability policy. And when you have an employment practices claim, such as a discrimination claim, it's certainly foreseeable that the terminated employee was terminated because of misconduct that the employee had committed against the employer. So I think that the insurance company has undoubtedly figured in, when it's doing its underwriting, that in some instances it may actually need to sue the terminated employee because of the misconduct that precipitated the termination. So they say that if you rule for us on this issue, the cost of premiums will go up. There's no evidence that the cost of premiums will go up.
Can I ask you a different question as to this, the question certified to us? Under the first question, it seems that the First Circuit is suggesting the possibility, anyway, that the Massachusetts law may either find a duty to prosecute a counterclaim under either the insurance contract or the in for one, in for all rule. Whereas the second question suggests that if there's a duty to fund the counterclaim that must be prosecuted, it would only arise under the insurance contract and not under the rule. So what happens if we decide that the duty to prosecute, if there is one, arises only under the in for one, in for all rule
And not the contract?
and not the contract?
There still is the duty to prosecute the counterclaim under the in for one, in for all rule. I believe the First Circuit wants to know, under any of these circumstances, whether it's under the insurance policy or under the in for one, in for all rule, does the insurance company have an obligation to fund the prosecution of the counterclaim?
Under the contract is what the second one seems to suggest. Where the insurance contract requires the insurer to cover defense costs.
To cover the defense costs.
Or the reasonable and necessary legal fees and expenses incurred by the insurer or by any attorney, blah, blah, blah. But that seems to suggest that the right to funds would only come as a result of the contract language. I don't know, maybe I'm misreading the question.
Frank, I looked at these questions, and when I first saw these questions, I thought fundamentally these two questions are asking the same thing. In other words, by what pathway do you get to the insurance company being required to fund the prosecution of the counterclaim? Is it under the in for one, in for all rule, or does that rule say no, they don't have to fund the prosecution? Or is it because of the language in the insurance policy? And so I view these two questions as essentially being overlapping, which is why I think that there are really only two questions the court needs to decide, and that is, does the insurer have the obligation to fund the prosecution of the counterclaim? And does the insurer's interest in devaluing the counterclaim give the insured the right to select independent defense counsel?
But wouldn't it be possible for the insurer to have a duty to prosecute it but not to pay for it?
No. For the insurer to prosecute it but not pay for it?
Yep.
No, because
For just the counterclaim?
No, because you would say, if there is a duty to prosecute, that inherent in that is that the insurer is paying for the defense.
that's correct. Same as if there is a duty to defend. That means the insurance company has to pay for that defense. And we say that the defense includes the prosecution of the counterclaim. That's all part of the defense. Thank you.
Thank you. Mr. Duane, good afternoon.
Good afternoon, Your Honor. May it please the Court. My name is James Duane, and along with Scarlett Rajbanshi, we represent Mount Vernon Fire Insurance Company in this matter. The Court is correct in focusing on the policy language. That is the contract at issue in this matter. It governs the relations between the parties, and the contract sets forth the rights and obligations. And the contract, the policy, talks about claims first made against the insured.
As a practical matter, okay, I hear what you're saying, but you agree that this is a compulsory counterclaim.
Yes, Your Honor.
So, as a practical matter, when that happens, how does it work before a jury?
In terms of the presentation of the counterclaim?
Right.
Well, Your Honor, and I can only go by personal experience here, in the cases that I've had that have been like this, I have defended the case in chief, and then the attorney for the insured puts in the evidence on the counterclaim. Now, there is oftentimes a lot of overlap, I will agree. If I were defending this case, I would certainly put in evidence of the forensic accounting that led Visionaid to believe that Mr. Sullivan had embezzled money. There's no question about that. That would take a little of the burden off the insured's counsel to put in that same information.
And then you don't, I mean, and maybe this doesn't come up, but I certainly remember from sitting in Superior Court that nobody ever wanted to let it be known to the jury, as though they never did know, that this is all insurance companies doing this.
That's right, Your Honor.
So how do you avoid that?
Your Honor, I think that that is one of the ways that cases are litigated. There is one attorney who's responsible for the defense of the case, and another attorney who is responsible for the prosecution of the counterclaim.
But your major point is that the craft of advocacy doesn't determine the rule, the contract does.
That's right, Your Honor.
So whatever the craft of advocacy might be, whatever's the better way to present the case, that's not what determines the language.
And that's right, Your Honor. And at pages 3 through 5 of our brief, which is page 35 of the appendix, the language is rife with defend against any claim and proceedings initiated against the insured. Nowhere does it talk about a duty to prosecute a counterclaim in that respect.
But, I mean, I guess two questions. The first is, would you not have an obligation of the McKinnon Rule to also present evidence of the fraud to limit the scope of damages?
And yes, Your Honor, and that's why the defendant, as part of its defense, would present evidence of the forensic accounting, which led the insured to believe, Visionaid in this case, to believe that Mr. Sullivan had embezzled money.
Okay, and would you not also include evidence that may be subsequent to the termination that would demonstrate that even though you did not know it at the time, he indeed had been stealing your funds?
Yes, Your Honor.
So you would be presenting then the entirety of that case as part of your defense?
Well, a good part of it anyway, Your Honor.
Which part would you not then?
Well, Your Honor, what I can think of in this particular situation, and I don't know because we haven't gotten very far in the underlying case, and I'm not defense counsel, but I would say that that Visionaid would still have to prove its damages.
It would be the amount that he had taken, Mr. Sullivan. That's what you say. I don't have to worry about that.
The fact that he had taken money and that Visionaid had a reasonable belief that he had taken money, not just they suspected, that they had a reasonable belief that he had embezzled that money would be sufficient, but there's nothing to say that the defense attorney wouldn't go beyond that and get into the more details on the forensic accounting.
Now, if you were put aside the insurance, if you were the attorney for Visionaid and failed to bring a compulsory counterclaim and they lost it, could they not sue your law firm for negligence?
I believe they could, Your Honor.
Okay, so your position is that the insurer can assign an attorney who will commit negligence?
No, Your Honor. The defense attorney has the obligation, in my view, to inform the insured, if they don't know it already, that they have a counterclaim and that they must bring it in this case.
Okay, but you have a strange situation in that the attorney for the insured would have an obligation to bring a claim which you are refusing to pay for.
That's correct, Your Honor, because we don't have a duty to prosecute affirmative claims.
So which means you don't have a duty to avoid negligence. You don't have a duty to pursue a course of action which would be negligence if done by a non-insurance attorney.
I believe that the attorney appointed to defend Visionaid in this case has an obligation to inform Visionaid that they have a counterclaim that they must bring within this action or lose it.
And would that be sufficient if you were not an insurance attorney? Would it be sufficient if I was representing Visionaid to say, we have a compulsory counterclaim, I don't plan to bring it, but you should hire somebody who would?
Your Honor, I would think that if it was a non-insurance attorney who was representing the company for various reasons, they would also bring the counterclaim, and they would make sure that it was brought.
It's basically I think what you're saying is that you do not agree with Mr. Berman that what defines the defense obligation here is what would a reasonable defense attorney do in a non-insurance.
That's right, Your Honor. It's governed by the language of the policy, and I would direct the Court's attention in particular to the Shoshone versus Pacific Employers case, a case which is very similar to this one.
What state does that arise out of?
It's a question certified by a federal court to the Supreme Court of Wyoming, Your Honor.
Wyoming.
In that case, there was a director of a bank who was terminated for various offenses. He brought a claim against the bank. The bank, in turn, had claims against him, and the Wyoming Supreme Court said, we are not going to torture the language of the policy to find a duty to prosecute a counterclaim where the policy says that the insurer's obligation is to defend the counterclaim.
Now, I think the argument here is that you have the contract on the one hand, and we also have the rule here, the one for one and for all rule. So I'm not sure that the rule is dependent on the contract language.
Your Honor, that's right. The GMAC case only held that if there is a covered claim in the complaint, the insurer has the obligation to provide a defense for all the claims. It doesn't provide that the insurer has the obligation to prosecute a counterclaim. The insured takes the position, Visionaid takes the position that the bringing of a counterclaim or the obligation to bring a counterclaim, a compulsory counterclaim is part of the rule. We say that that's not only an expansion of the current rule, but it is a new rule, and that is that if a counterclaim is compulsory, that the insurer has an obligation to prosecute that counterclaim on behalf of the insured and pay for it.
Visionaid says that position is that won't increase premiums.
I'm sorry, Your Honor.
Visionaid's position is that new rule would not increase premiums.
Your Honor, I don't know whether it would or wouldn't for sure. I know that there have been some amicus briefs that have made that argument with more compelling evidence than I could provide, but I do know that the cases that support the position that there is no duty to bring a counterclaim have stated that as a policy argument.
Do they have this rule, though, the in for one, in for all rule that we do?
In other states,
The ones that you say as policy matter.
they have
don't do it.
variations of it, whether they call it that or not.
Okay, because, I mean, one of the policy considerations there is efficiency, right?
Your Honor, the last...
Efficiency is one of
That's
the
right, Your
policy
Honor.
considerations.
That's right.
For the adoption of the rule to begin with.
That's correct, Your Honor.
And so on that rationale, one could make the argument that we're in these limited circumstances of compulsory counterclaims, that purpose is served.
Well, Your Honor, I would think that there's a distinction between covering every claim that's made in a complaint from a defense point of view and then bringing an affirmative offensive complaint that is not part of the policy language.
Well, but that arguably is intertwined with the claims that are made in the lawsuit.
Your Honor, every counterclaim could be helpful. Every counterclaim.
Right, but
Now,
not every counterclaim is inextricably intertwined, and this one, I mean, you've I think conceded that if you did not prosecute the counterclaim, you should present the totality of evidence of the wrongdoing in order to limit the scope of damages, correct?
that's correct, Your Honor.
So
But if,
you'd be presenting essentially the entirety of the counterclaim except the claim for damages.
I don't know exactly how it would play out, Your Honor, but that's my best guess at this point. I would say that in terms of the number of jurisdictions, there have been no jurisdictions in cases like this that have found an obligation to prosecute a counterclaim. The only time those jurisdictions, or the courts in those jurisdictions, have found such an obligation is when the counterclaim would offset or defeat liability. And that's not just for counterclaims, it's for cross-claims and third-party complaints.
So could you give me an example?
Yes, Your Honor. For example, if a homeowner who hired a home improvement contractor sued the contractor for something, and the contractor has a subcontract with one of his subcontractors that provides that the subcontractor provide him with complete indemnity, that would be an example of a situation where the insured would have a third-party claim, essentially a counterclaim, that would absolve it of liability if proven at trial.
Well, but here, don't we have the arguable circumstance of using the counterclaim defensively to beat Mr. Sullivan down from his original offer of $400,000, I think, or whatever it was that he wanted, to zero, so long as he gets a release from the counterclaim?
What we have here, Your Honor, is an example of using the evidence that would be used in support of the counterclaim.
Wasn't a counterclaim made here?
The counterclaim has been made, but I believe...
After, the counterclaim was asserted before these settlement discussions.
No, Your Honor, I believe, and I may be wrong on this, but if you look in the facts, the settlement negotiations were proceeding prior to the initiation of the counterclaim, and in fact, just I think Visionaid's counsel argued that just the threat of the counterclaim significantly reduced it before the counterclaim was actually brought.
Okay.
So the insurer could choose to bring it, but is not obligated to bring it?
That's correct, Your Honor.
So you can bring it whenever you want to, because it may reduce it, and because it would reduce the overall claim and be for the benefit of the insured. But when you don't feel like it, you don't have to?
Well, when there's the only obligation to bring a counterclaim is when it would offset or defeat liability.
So if they were to say here that if in the unlikely event we are liable and prevail on the counterclaim, we will allow the counterclaim damages to offset whatever our liability is, then you're in?
This would not be an offset, though, Your Honor.
What
In
if
this
they
particular case.
what if they were agree that it should be an offset, or that they were treated as an offset?
Well, that's not this case, Your
Okay,
Honor.
so your view is that it would not be an offset because arguably it could occur subsequently.
Well,
It would have to be. It would have to be subsequent because otherwise it wouldn't be irrational.
It's not legally an offset.
That's
It
correct, Your
may, as a
Honor.
practical matter, be an offset, but it's not legally an offset.
Well, it wouldn't be, actually, because what would happen is if there was a judgment for Sullivan for $100,000 and a judgment for Visionaid for $100,000, Mount Vernon would be paying the judgment for $100,000, but Visionaid would recoup the $100,000.
So what if we said your obligation is limited to where there is a compulsory counterclaim and it's inextricably intertwined, and the insured agrees to offset with the amount of the counterclaim whatever damages the insurance company has to pay?
Well, courts have found that the counterclaims like this are not inexplicably intertwined. If you're posing the hypothetical that
I think you
it
mean
was.
inextricably, not inexplicably.
Inexplicably,
Inextricably.
okay. Okay, but that would be a factual finding then by the federal court, not by us, but they ask us for a standard. So I'm asking you to respond to a standard which would say to the federal court, 3 requirements: compulsory, plus inextricably intertwined, plus the insured agrees that any damages that would be obtained through the counterclaim would offset the damages that the insurer would otherwise have to pay.
The answer to that, Your Honor, would be no, because of the language of the policy, which doesn't provide an obligation for the insurer to prosecute a counterclaim. If I might just add one other thing, in all of the cases that support an obligation to bring a counterclaim, not only were they cases in which the claim brought by the insured against a third party would defeat or offset liability, but they were all cases in which the insurer had denied coverage. So the insured was able to bring the counterclaim without the insurer being involved. So, they didn't defend at their peril.
Do we have any cases with the insurer involved, as here?
We do not, Your Honor, as far as I know.
Like sort of the split?
The split is on the basis of whether it's going to get an offset or a recovery for the insured.
No, I understand. Well, maybe I didn't ask the question properly. Are there cases out there with facts like these where the insurance company has agreed to defend but not to prosecute a counterclaim?
Oh, yes, Your Honor. The cases that we cite, the Shoshone
And
Bank.
any of them in which the duty to prosecute has been found?
No, Your Honor.
Okay, thank you.
Thank you.